Hello, everybody. Hope everybody had a good weekend and snow day today. Also, it was snowing a little bit today. We're gonna now resume what we were talking about before on the Article 5 of the B101, 2000, I believe 17, honors responsibilities. Yeah, there are some responsibilities for the owner. Anybody can tell me what they believe the responsibilities from the owner may be as per the B101, just from the top of your head.
Um,
Basically providing anything related to the site and to the existing conditions.
Yeah, I can't really hear you that well, Alan.
Can you hear me better now?
That's a little bit better, right, Miranda?
Yeah, basically providing anything related to the site and to existing conditions.
Yeah, a little bit of that. We spoke about it at the very beginning. And then anything else, Miranda?
yeah, like Alan said, everything pertaining to the site. So, like site surveys, geotechnical, they would furnish that consultant. And um, yeah,
So there
I
are
think,
two things that I would think of that we as architects will need from the owner. Like really, 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 really important. Two things. Can anybody try to say those two things? You kind of mentioned one already, but
program.
Upfront payment.
payment and a site. And then the program, yeah, is the project, right? Payment, site, project. All right, so let's go through that right now. Good job. So Article 5, owner responsibilities 5.1 says, unless otherwise provided for under this agreement, the owner shall provide information in a timely manner regarding requirements for and limitations on the project, including a written program, good job, which shall set forth the owner's objectives, schedule, constraints, and criteria, including space requirements and relationships, flexibility, expandability, special equipment, systems, and site requirements. The owner shall 5.2. The owner shall establish the owner's budget for the project, including one, the budget for the cost of the work and as defined in section 6.1, and two, the owner's other costs, and three, reasonable contingencies related to all of these costs. Why do we have contingencies, guys? What is a contingency and why do we have contingencies? Miranda.
I think about contingencies and payment. So, making sure you're paid on time and relative to the. Um,
Yeah, contingencies are really a buffer. All right, so as you can see, they define it as one, you got to have a budget for the cost of the work, two, other costs of the work, and then three, it says reasonable contingencies related to all of these costs. Meaning, well, if you have a budget for 1 million, do you only have 1 million? What about 1.1, 1.2, right? Typically is anywhere from 10 to 20% of the costs associated with that item that is saved aside as a contingency amount. And then the owner shall update the owner's budget for the project as necessary throughout the duration of the project until final completion. If the owner significantly increases or decreases the owner's budget for the cost of the work, the owner shall notify the architect. The owner and the architect shall thereafter agree to a corresponding change in the project scope and quality. Well, I always say this to you: if the owner happens to just win the lottery and he wants to make a bigger building, he should update the budget and also update the cost of the scope of work and compensate us accordingly. We got to get paid according to the amount of that. So also, if the owner was to actually lose money and almost be bankrupt, and he wants to reduce the scope prior to us really designing it, we can reduce the budget, reduce the but they reduce the budget, and we can reduce the scope of work and get paid less. The owner 5.3. The owner shall identify a representative authorized to act on the owner's behalf with respect to the project. The owner shall render decisions and approve and approve the architect's submittals in a timely manner in order to avoid unreasonable delay in the orderly and sequential progress of the architect's services. Very important. Time is of the essence. Section 5.4 says the owner shall furnish surveys, good job, Alan, to describe physical characteristics, legal limitations, and utility locations for the site of the project, and a written legal description of the site. The surveys and legal information shall include, as applicable, grades and lines of streets, alleys, pavements, and adjoining property and structures, designated wetlands, adjacent drainage, rights of way, restrictions, easements, encroachments, zoning, deed restrictions, boundaries, and contours of the site, locations, dimensions, and other necessary data with respect to existing buildings, other improvements and trees, and information concerning availability, available utility services and lines, both public and private, above and below grade, including inverts and depths. Remember that word inverts and depths. All the information on the survey shall be referenced to a project benchmark. Section 5.5 says the owner shall furnish services of geotechnical engineers, which may include test borings, test pits, determinations of soil bearing values, percolation tests, evaluations of hazardous materials, seismic evaluation, ground corrosion tests, and resistivity tests, including necessary operations for anticipating subsoil conditions with written reports and appropriate recommendations. Basically, the site in general, right? Section 5.6, the owner shall provide the supplemental services designated as the owner's responsibility in section 4.1.1, which we were already talking about. 5.7 says if the owner identifies sustainable objective in Article 1, the owner shall fulfill its responsibility as requiring NAI document E204 2017, Sustainable Project Exhibit attached to this agreement. 5.8, the owner shall coordinate the services of its consultants with those services provided by the architect. The owner shall coordinate the services of its consultants with those services provided by the architect. I'm going to say it one more time. The owner shall coordinate the services of its own consultants with those services provided by the architect. If the owner was to hire an interior designer, and the interior designer is doing some color samples, some colors, textures, and things like that, and we're designing the walls where those textures are going to go, the owner is in charge of making sure that those walls are where they're supposed to go and that they're coordinated. And it may happen through the owner where we actually email the consultant interior designer through the owner and we talk to each other, but the owner really is the one in charge of coordinating those services with us. And that is a very important question. Upon the architect's request, the owner shall furnish copies of the scope of services in the contracts between the owner and the owner's consultants. Upon the architect's request, again, the owner shall furnish copies of the scope of services in the contracts between the owner and the owner's consultants. Why do you think that is? An idea? I guess I'm gonna answer it. Miranda. Oh, Miranda needs coffee. So the reason why is because, first of all, I would want to see what the heck is this consultant doing that I couldn't do. I could have given that service myself, right? The other thing is I also want to see whether it is needed, that service is needed. A lot of very wealthy clients start hiring all these kinds of consultants, and they're like paying a ton of money for services that they quite frankly don't need. The other thing, and probably the most important thing, is so that we understand what is that consultant doing versus what I'm doing, and what's the overlap, and is there anything missing that he should be providing that nobody knows who is providing, and that might create a problem. All right. So, upon the architect's request, the owner shall furnish copies of the scope of services in the contracts between the owner and the owner's consultants. The owner shall furnish the services of consultants other than those designated as responsibility of the architect in this agreement. So, any other consultant that's not under the architect, then the architect, has the mechanical, electrical, plumbing, and structural engineer. That's like the standard, type of relationship. So, Sometimes the owner hires interior designer, audio visual consultants, AV, and specialty consultants to do certain things that are inherent to the project that we don't even know about. So they have to deal with those, not us, not the architect. All right. Or authorize the okay. The owner shall furnish the services of consultants other than those designated. Okay. If the owner doesn't do them, then authorize the architect to furnish them as an additional service. When the architect requests such services and demonstrates that they are reasonably required by the scope of the project, well, that's the point. That if they're required and the owner is not doing them, then the owner needs to provide them, or we provide them, and then they have to approve them. And it's because time is of the essence. So if we need an audio visual team, we gotta get it. The owner shall require that its consultants and its contractors maintain insurance, including professional liability insurance, as appropriate to the services or work provided. Then section 5.9, the owner shall furnish tests, inspections, and reports required by law or the contract documents, such as structural, mechanical, and chemical tests, tests for air and water pollution, and tests for hazardous materials. This is a programming and analysis kind of item. And it again says that the owner shall furnish the tests, inspections, and reports required by law or the contract documents, such as mechanical, it's a structural, mechanical, and chemical tests, tests for air and water pollution, and tests for hazardous materials. So these are the tests that typically some of these might include tests that need an environmental site assessment, ESA, and they are about I guess there's three phases. One is just the general recon, but then the first one they call it phase one, and then the other one they call it phase two. But I think that there is one right before those two. But phase one is an observation. Phase two environmental study site assessment is an actual testing. It's when you actually test the grounds. Okay, the grounds or sampling or whatever it is that you find on the soils. Section 5.10, the owner shall furnish all legal, insurance, and accounting services, including auditing services that may be reasonably necessary at any time for the project to meet the owner's needs and interests. The owner shall provide 5.11. The owner shall provide prompt written notice to the architect if the owner becomes aware of any fault or defect in the project, including errors, omissions, or inconsistencies in the architect's instruments and services. That's a very good one, guys. If the owner notices something, they gotta call you. Being quiet about it is the worst thing that they can do because we're not covering them then. Section 5.12, where Miranda go? The owner shall include the architect in all communications with the contractor that relate to or affect the architect's services or professional responsibilities. So the owner cannot just be emailing the contractor by itself. They have to email the contractor and add us in it. We must be aware. The owner shall promptly notify the architect of the substance of any direct communications between the owner and the contractor, otherwise relating to the project. Communications by and with the architect's consultants shall be through the architect. Very, very important, guys. Very, very important. Okay? I'm going to repeat it again. So the owner shall include the architect in all communications with the contractor that relate to or affect the architect's services or professional responsibilities. So the owner has to email through the architect, with the architect added in there. Even if the email is directly to the directly related to that project. I'm sorry. I'm going to pause this meeting for a second and then I'm gonna resume it in a minute, all right? Just 1 second. So as I said, I'm gonna repeat this one again. And the reason why I'm repeating it is not just to bore you out of your mind. It's really because these are questions. These are items that get asked, topics that get asked. And if you don't understand who is supposed to be talking to who, you will not be able to actually respond effectively to the issues at hand. So I want you to be able respond to everything effectively. So the owner shall include the architect and in all communications with the contractor that relate to or affect the architect's services or professional responsibilities. Everybody can see that first part? Yeah. The owner shall promptly notify the architect of the substance of any direct communications between the owner and the contractor otherwise relating to the project. And direct communications really means they were talking on the phone or they were talking in person, they were texting each other, right? That's not somewhere where the architect is involved. They gotta let us know what they're talking about if it's related to the project. And communications by and with the architect's consultants shall be through the architect. So the owner, if there's a question that says the owner was talking to a structural engineer about beam size, what was the architect there? What's the deal? The first thing that the consultant, the structural engineer should say is, we got to have the architect here. We can't talk about it. And it sounds weird, but it's really the best way. We have to have the architect involved. So section 513 says, before executing the contract for construction, you know what that means before executing the contract for construction. It's not before the work is done or the construction is done. It's before they have signed the contract. Because execution of a contract is signing the contract. And the moment you sign it is when you have executed the contract. That's the term that they use. So before the execution of the contract, the owner shall coordinate the architect's duties and responsibilities set forth in the contract for construction with the architect services set forth in this agreement. Well, really, it's saying that, hey, if the owner and the contractor aren't using the A101 and the A201, we got to know what are the services the architect's going to be doing. All right. And we need to know, because if they're not using a standard A101, then we're kind of on limbo. And then the A201, we're kind of on limbo because we're using or B101 that is actually interrelated with the rest of them. The owner shall provide the architect with a copy of the executive agreement between the owner and contractor, including the general conditions of the contract for construction. A201 that we just said. The owner shall provide the architect access to the project site prior to commencement of the work and shall obligate the contractor to provide the architect access to the work, whatever it is in preparation or progress. So it doesn't matter what stage it is, we got to be able to go there. All right. So that's very important, guys. We have to be able to go to the site. The owner has to allow us in there, and the contractor has to allow us in there. Section 5.15. Within 15 days after receipt of a written request from the architect, the owner shall furnish the requested information as necessary and relevant for the architect to evaluate, give notice of, or enforce lien rights. Okay, 15 days. Now we go to Article 6. All right, no questions so far? So Article 6, cost of the work. Anybody knows what the cost of the work is?
The cost of construction.
Right. So and cost of the work could be cost of a little portion of the job or whatever, but it's all part of, and then there is cost of the project, which is the whole thing. So let's go ahead. Section
So
6.
cost of the work doesn't include architecture fee.
No, it does not. So section 6.1. For purposes of this agreement, the cost of the work shall be the total cost of the owner to construct all elements of the project design or specified by the architect and shall include, listen to this, contractors' general conditions, costs, overhead, and profit. The cost of the work also includes the reasonable value of labor, materials, and equipment donated to or otherwise furnished by the owner. The cost of the work does not include the compensation of the architect, right? We got that? The cost of the work does not include the compensation of the architect. The cost of the land also is not included. Oh, hold on. Does not include the compensation of the architect. The cost of the land, rights of way, financing, or contingencies for changes in the work, or other costs are the responsibility of the owner. So none of those other ones that I just mentioned, the architect, the cost of the land, rights of way, financing, contingencies, changes in the work, or costs that are responsibility of the owner, they're not included on the cost of the work. It's everything that gets paid to the GC is a cost of the work. Okay. So 6.2, the owner's budget for the cost of the work is provided in the initial information and shall be adjusted throughout the project as required under sections 5.2, 6.4, and 6.5. Evaluations of the owner's budget for the cost of the work and the preliminary estimate of the cost of the work and updated estimates of the cost of the work prepared by the architect represent the architect's judgment as a design professional, right? It's just the judgment as a design professional. It is recognized, however, that neither the architect nor the owner has control over the cost of labor. I mean, COVID showed it. Labor and materials went up, and or equipment. The contractor's methods of determining bid prices or competitor bidding, market, or negotiating conditions. We have zero power or authority over any of those things. Accordingly, the architect cannot and does not warrant or represent that bids or negotiated prices will not vary from the owner's budget for the cost of the work or any estimate of the cost of the work or evaluation prepared or agreed to by the architect. We try to design to the owner's budget. We don't warranty or guarantee that it will be met. Okay. Section 6.3 says, in preparing estimates for the cost of the work, the architect shall be permitted to include contingencies for design, bidding, and price escalation to determine what materials, equipment, component systems, and types of construction are to be included in the contract documents, to recommend reasonable adjustments in the program and scope of the project, and to include design alternates as may be necessary to adjust the estimated cost of the work to meet the owner's budget. The architect's estimate of the cost of the work shall be based on current area, volume, or similar conceptual estimating techniques. Could be a cost per square foot, could be a cost per linear feet, things like that we use here in, let's say, Massachusetts. If the owner requires a detailed estimate of the cost of the work, the architect shall provide such an estimate if identified as the architect's responsibility in section 4.1.1 as a supplemental service. It's above and beyond what we typically do and any other reasonable and prudent architect does. So we got to charge a little bit more and hire an actual consultant to do it. And I haven't really been offering this as a service, but it may be a good idea to have an estimator to do some of this stuff for us. So section 6.4, so this, if through no fault of the architect, the procurement phase has not commenced within 90 days after the architect submits the construction documents to the owner's budget for the cost of the work shall be adjusted to reflect changes in the general level of prices in the applicable construction market. Well, I have a little story for you guys. So here for design, we have a 4-step process for our designs. Step 1, existing conditions. Step 2, inspiration, sort of vision board concepts and ideas. Step 3, we'd start testing the concepts and ideas and generate design options. Step 3 is a really design as we know it from school. And that's when we generate 2 design options. We generate 2 design options, and more often than not, owners want to stop the work at that point because they want to get pricing for those 2 design options so that they can decide which option is the best. Sometimes they do make a decision based on their preference and they don't know what's going to cost and how much it's going to cost and anything about it. They just simply like it. I like when they make decisions on whether they find an option more efficient than the other. And I don't like so much when they base it on just the budget as the decision factor, the deciding factor. Why? Because then we get put on hold until they get 10 contractors to bid on those preliminary drawings that don't have sizes of members or they're not really, articulated as a construction document set, because it's a schematic. Schematic doesn't have wall sections and details. So it tends to be a little bit misleading. but it happens, and it happened at least once, and that's why in our contract now we give people 7 days to pick an option. So from now on, if they don't pick an option after 7 days, we charge an additional service fee for the delays on the project. And it is because I don't want to be at the mercy of contractors to bid on the job and then you find a price that makes you happy so you can proceed with the design. I want you to make an informed decision based on all the information that we've provided that tells you what option A is and what option B is and what the pros and cons of those two options are. And I can generally give you an idea of which one I think is going to cost more. And that will leave it at that, end there. So, those projects are very small residential jobs. So, we don't have the 90-day commencement situation that we talked about. But it's still, I have that 7 days. And then after I do construction documents and I finalize them, I tend not to do construction administration on residential jobs. So that doesn't affect me. But the point I'm trying to make is, we shouldn't as architect, have to just hang around for somebody then to make a decision on pricing and contractors to bid on a job and things like that. We don't want to be held hostage, right? Our checks being held hostage because somebody hasn't decided on something. So we got to make sure that our designs, and this is just my personal opinion, are clear enough so that they can make a decision based on the value and the efficiency of the design itself, not just which one is $1, which one is $2. And then going back, if through no fault of the architect, the procurement phase has not commenced within 90 days after the architect submits the construction documents to the owner's budget for the cost of the work shall be adjusted to reflect changes in the general level of prices in the applicable construction market. And the reason why I also stopped here is because in that example I made, guys, turns out that contractors weren't bidding on the job. It was all the way back in March, April, June, July. I mean, it went on, and they didn't have any pricing. And then what we designed in March could have been done for the client's budget, but what the bids were all the way in September, October of 2020 was a whole different story. And they were kind of blaming us for it, but in reality, it has nothing to do with us. The bidding phase didn't start within the 90 days. It was many months after. And in COVID years, or in COVID days, a day is a year. I mean, we've been losing 14 days of our lives every other week, basically. Every 2 weeks, we're like 14 days quarantine again. So it's like 14 day turns into, we just lose a month into 14 days. So, and the price has doubled. Now the client was very upset with Flow, with my company. I'm like, why? Well, you didn't design to our budget. And I was like, we designed to your budget all the way back in March, April. Your budget was nothing by the end of September, October, November, maybe in December. Because when you could buy a 2x4 for $2.10, now you have to buy it for $5. It has nothing to do with Flow. So what this element here, this Article 6.4 is saying is we gotta adjust the budget or the this estimate to meet the requirements of today, like inflation and changes in the current market. And I'll tell you later what the reasoning is on the AIA because on this contract, because mine is just my personal story. I don't want to be held hostage and not get paid and things like that. But on this, we are ethically and contractually bound to meet the owner's budget. On my contracts, I try as much as I can, but I'm not doing the AIA contracts. So this one makes you have to design to the owner's budget. And if you don't design to the owner's budget and it's above by a lot, you have to redesign it for free. Yes, you have to redesign it for free. If it is because you just simply didn't even think about the budget, you just designed something outrageously expensive. So
I have a quick question in regards to that.
go for it.
On the case that you do a project and you do the estimate on the office and you are still on budget, but when it goes to bidding, it just exceeds for some reason. But in your estimate, you're still were in the budget? Are you in fault? Do you have to redesign the part of the project, or how does that work?
Yes, you do have to go back to the drawing board, but the first thing that you got to check is when did they get the proposals? When did they go out for bid? Was it within these 90 days? If it's not, if it was after 100 days, 300 days, you don't have to. I would argue even contractually, you don't have to redesign to the owner's budget because if you wait way too long. If it is within that reasonable time and it is by a lot that you're off, like meaning like a ton, you do have to go back to the drawing board. If it is, there is a 10-20% contingency. If you're within that contingency, you should be okay. You shouldn't have to redesign it. Okay. And we're going to get the answer to that very soon, actually. 6.5. If at any time the architect's estimate of the cost of the work exceeds the owner's budget for the cost of the work, the architect shall make appropriate recommendations to the owner to adjust the project size, quality, or budget for the cost of the work. Sorry, and the owner shall cooperate with the architect in making such adjustments. Now, you remember all the way back in the architect responsibilities and services, we were talking about schematic design. We first do our cost of the work estimate. Then on design development, meaning at the end of schematic design, we make any recommendations to the estimate. And then at the beginning of the design development, we use those recommendations, whether he has assimilated them and used them or not. And then we incorporate them in there. And then we revise that at the end of design development. And then we begin construction documents with that. And then at the end, we make any other final recommendations or revisions to that cost of the work finalized at the end of construction documents. So we create the cost of the work, the estimate once, a schematic design, and we update it at each phase, at the end of each phase. Okay. So, and that's what it's saying here. It's repeating something that we have already read before. Section 6.6 says if the owner's budget for the cost of the work at the conclusion of the construction documents phase is exceeded by the lowest bona fide or negotiated proposal, the owner shall, 1, give written approval of an increase in the budget for the cost of the work, 2, authorize rebidding or renegotiating the project within the reasonable time, 3, terminate the whole contract in accordance with 9.5, 4, in consultation with the architect, revise the project program scope and or quality as required to reduce the cost of the work, or 5, implement any other mutually acceptable alternatives. So you see what it's saying is that if at the end of CDs, right, we produce our own estimate, and the lowest bidder, the lowest person that bidded or negotiated the proposal exceeds that budget, then we have to resource to these 5. And number 4 is the one that we care about. If the owner can actually say, nope, we're gonna go back to drawing a little bit more and we're gonna make some changes. That's it right there. So the owner can, 1, revise the budget, increase it. 2, try to rebid it again with many other players. Maybe one of them will be lower. 3, terminate the whole contract. 4, redesign the project. 5, implement any other mutually acceptable alternatives. That may be a combination of 2. Like, actually, if you were to, you can't really combine 2 here. Oh yeah, you could you still have to, if you revise the budget, you're gonna have to, I guess you can pick one of them. You don't have to rebid it. But if you redesign it, then you have to rebid it, so. Section 6.7, the owner chooses to proceed under section 6.6.4. This one right here. Okay. If the owner chooses to do this, if the owner chooses to, in consultation with the architect, revise the program, scope or quality as required to reduce the cost of the work, The architect shall modify the construction documents as necessary to comply with the owner's budget for the cost of the work at the conclusion of the construction documents phase services, or the budget as adjusted on section 6.6.1, which is the first option there. If the owner requires the architect to modify the construction documents because the lowest bona fide or negotiated proposal exceeds the owner's budget for the cost of the work due to market conditions the architect could not reasonably anticipate, the owner shall compensate the architect for modifications as as an additional service pursuant to section 11.3. If it was something that was not reasonably inferable, that we could have never known, like COVID, prices of lumber went all the way up. We could have never dreamed that that was going to happen. I mean, if I had, I would have bought all the lumber at Home Depot and I would have resold it. It would have been like the stock market, buying low and selling high. So, but we could have never really anticipated it. So if we couldn't, then we get compensated as an additional service fee, for an additional service fee to redraw the project. Now, otherwise, if the architect service for modifying the construction document shall be without additional services. So if it wasn't because of something we could have never foreseen and we kind of saw it coming and we still didn't do anything about it, meaning we were kind of like we knew we were over and we knew we were going to be over by a lot and we didn't do anything about it, well, this word's going to hurt. Otherwise, the architect's services for modifying the construction document shall be without additional compensation. Does it make sense? Everybody gets it. Am I saying that money is gonna pour out of my pocket if I don't design to the owner's budget, I disregard it, and I'm all the way over, and it has nothing to do with market conditions? Yes, it's your fault. That's it. You're redesigning. If it has to do with market conditions that you could have never dreamed of or imagined, such as COVID or a hurricane or something like completely absurd, you get compensated additional services for redesigning it. Okay? In any event, the architect's modification of the construction documents shall be the limit of the architect's responsibilities under this Article 6. That's as far as we go. That's it. We don't do no more after that. So Article 7, copyrights and licenses. So 7.1, the architect and the owner warrant that in transmitting instruments of service or any other information, the transmitting party is the copyright owner of such information or has permission from the copyright owner to transmit such information for its use on the project. You know, typically the one that's transmitting is the architect because we're the ones that create our instruments of service. So he says the transmitting party kind of owns them or has limited copyright from the owner. Section 7.2, and this is a good one. The architect and the architect's consultants shall be deemed the authors and owners of their respective instruments of service, including the drawings and the specifications, and shall retain all common law, statutory, and other reserved rights, including copyrights, submission or distribution of instruments of service to meet official regulatory requirements or for similar purposes in connection with the project is not to be construed as publication in derogation of the reserved rights of the architect and the architect's consultants. I mean, we got to disclose it to the building department. We shouldn't be like that's not breaking the law. Mm. All right. So then we go to section 7.3, and I got this send a message here. Can someone please explain what's the one of that? That's a good question. So that's a yeah. She answered it. Miranda said it's the lowest one of feed I don't know feed bidder means guaranteed. So the lowest one is the lowest sort of um guaranteed price that you get for the cost of the work. It's a term to say the lowest person that bid on the job. If that lowest person is still higher than your estimate, and it's not because of COVID or anything weird, you got to redesign. No additional service. All right. And it's just a term. I honestly don't really. It's just a term. Um, Then we go to section 7.3. The architect grants to the owner a non-exclusive license to use the architect's instruments of service solely and exclusively for purposes of constructing, constructing, using, maintaining, altering, and adding to the project, provided that the owner substantially performs its obligations under this agreement, including prompt payment of all sums due pursuant to Article 9 and Article 11. The architect shall obtain similar non-exclusive licenses from the architect consultants consistent with this agreement. The license granted under this section permits the owner to authorize the contractors, subcontractors, and subcontractors and suppliers, as well as the owner's consultants and separate contractors, to reproduce applicable portions of the instruments of service subject to any protocols established pursuant to section 1.3, solely and exclusively for the use in performing services or construction for the project. The mouthful, guys. Can somebody just grab those drawings and build another project in China that looks exactly like it and is exactly like it? Anybody? Nobody?
I don't think so.
No, absolutely not. I mean, they can, but they will get sued. I mean, they can do anything, but it's illegal.
Actually, if you're talking about China, everything is possible.
Probably. If the architect rightfully terminates this agreement for cause as provided in section 9.4, the license granted in this section 7.3 shall terminate. What it's really saying is that the architect just, you know what, he didn't get paid, or the owner substantially defaulted on his duty as to, paying or responding to answers. And the architect says, you know what, I'm done with this. I am hereby terminating the contract for cause. Then the owner cannot continue building that same building that you designed up to that point, believe it or not. So they can't do it. 7.3.1, in the event the owner uses the instruments of service without retaining the authors of the instruments of service, right? Because you probably had that question coming. The owner releases the architect and architect's consultants from all claims and causes of action arising from such uses. The owner, to the extent permitted by law, further agrees to indemnify and hold harmless the architect and his consultants from all costs and expenses, including the cost of defense related to claims and causes of action asserted by any third person or entity to the extent such costs and expenses arise from the owner's use of the instruments of service under this section 7.3.1. The terms of this section 7.3.1 shall not apply if the owner rightfully terminates this agreement for cause under section 9.4. Okay, this is a big one, and I don't expect that you will get it right on this one shot. Read it and reread it again. But in a nutshell, what it's saying is that if the owner fires you, not if the owner fires you, if you quit, like you quit the job because the owner hasn't been paying you, you're done. The owner moves on and grabs your drawings and gives it to, let's say, their cousin who happens to be an architect in another country and happens to know how to draw. And they're no architects. Well, that's the first thing. They're already violating the law because they shouldn't be working on that project. And that actually happened. So I'll make a little example of this. We didn't necessarily get fired. We didn't get fired, and the owner, and we didn't quit the job either. We finished the drawings. We gave them to the owner. The owner then asked us to provide AutoCAD files. We provided the AutoCAD files. Then we saw that the owner grabbed those AutoCAD files, gave it to their cousin from another country, and they tweaked the whole design and changed the whole thing around. They did not change the foundation because they were already starting construction. They found a lot of issues with our drawings, supposedly. Just so you know, they paid 1% of the fee that the contract was supposed to be. We didn't fight it. We didn't argue it. We just did it for that 1%. And, we're not going after them. We will probably never go after them for anything like that. We were acting in good faith, and we just wanted the project to move forward. They did the whole thing. Now, it's kind of outrageous because I now go to Instagram, and I see them posting pictures and videos of the whole project, and they have all this copyright information about the project and how it is their property, and if anybody reproduces or copies or shares any of them without their express knowledge and consent will get sued. And they don't even say, hey, by the way, this was designed by Flow Design Architects. Like, what? Really? So they don't even say our name at all. They don't say anything about us. And we're actually waiting for the project to sell and somebody else buy it, so that we go there, talk to the new owner, and say we're gonna do a photo shoot, because we really don't want to continue the relationship with this client, for many, many reasons. But the whole point here is that, are they in breach of contract? Yes, absolutely. They should have not gone and gotten somebody that's not licensed to modify licensed drawings that was a limited license for that particular project that was completed. Now, are we going to sue them? No. All right. Now, if he was, now those clients actually say a lot of bad things about us. It's just the way they are. That's how they are. They just talk. But they never fired us. They never, absolutely never fired us. They never wrote a warning or a complaint with us. They were always in love with us until their cousin came from their other country and happens to be free. That's when they said, you know what, we overpay for these services. That we should have never had them. We should have had our cousin, but the cousin didn't even have a visa. So, we did our services when we needed to do our services. And now that cousin is kind of taking on the jobs with them. Good luck and God bless them. But they should not be modifying the instruments of service without notifying us, because there's a copyright infringement there. Now, if they were to have fired us, terminated us for whatever cause, then at that particular time, that particular moment, they would not be in violation of the copyrights. In fact, it would have been better for them to fire us and hire that cousin from Albania, so that or China, or whatever they are from, so that they can continue. That would have been better. They would have not been in breach of contract. So, long story short, now, because of the fact that somebody else touched our drawings and changed them, then this applies. The owner has to release us. They can never come back to us. Release us. Now, that's if we're using the AIA contracts. Our contracts have something like this, though, so we're good. Owner releases the architect and architect consultants from which claims and causes action. So if something is wrong later on, they can't come and say, hey, Flow Design was involved in that. It's like, yeah, we were involved, but then you hire such and such to finish it. And at that moment, it's kind of like when you open a laptop or a computer, it has a little sticker that says, if you open this, it will waive the guarantee. So at that moment, you touched it, you just lost every guarantee. So they have to not only look at this. So this is a mouthful, like I said. Not only are they going to release us from any sort of liability and claims, right, arising from using this, but also they got to identify us and hold us harmless. And identifying, you know what identifying means? Identifying, anybody knows what identifying means?
It means to hold harmless. Oh, I guess it says it there.
Identifying and hold harmless are two different things, buddy.
So identifying kind of guarantee that you're not like guilty or in fault.
Identify is a contractual obligation for one party to compensate the loss incurred to the other party due to the acts of the minor or any other party. The duty to identify is usually, but not always, coextensive with the contract duty, hold harmless or safe harmless. Basically, they gotta pay us for our trouble. Okay? So if they were to be suing us for this, they will have to pay us for the time that we have spent on this, fighting these claims, and we are held harmless. We did nothing wrong, we pay you nothing. So they got to pay us. You got to identify me for my trouble, and you got to hold me harmless. So then it says, in the act that any consultants and any costs and expenses, including the cost of defense. You know what the cost of defense means? What kind of defense do we talk about here?
Lawyer?
That's right, attorney fees. So they pay for our attorney fees. Yep. So if they were to sue me, we will go to court, and they will have to then, at the end of the court proceedings, pay all of my attorney fees. I could hire the most expensive attorney in Boston. I will pay it in the meantime. You start paying it, like, as you have to start paying it. But then after that, they will have to pay you back. We actually got into something like that in March last year because of the COVID situation. We were late by like a day or two on delivering some drawings, which was reasonably inferable. Understanding that we got shut down and nobody wanted to come to work. I mean, even Albelis didn't come back to work. That was the last time I ever heard of you, Albelis, right? March, February, nobody came back to work. Work got shut down. It was really like, it was scary. It was scary for everybody. Long story short, these guys were trying to we lost Juan, we lost Becky, we lost the whole office. It was like a disaster. And these clients wanted to they hired another company, and they wanted us to indemnify them and pay them back. They got an attorney. It turns out that they had to settle the matter because we never breached our contract, and our contract says if we are late by a few days or anytime for reasons beyond our control, like say the office burns down, there is a storm that doesn't stop, 2 of the architects of the office happen to have died or whatever, God forbid, we cannot be sued for that stuff. It's just not, we cannot, they have to hold us harmless and identifiers. Well, long story short, we call an attorney. The attorney looked at our contract and said, dude, not only are you covered, because they definitely breached their contract, but also they will have to pay me for the fees. Now, the attorney was like $400 per hour. I didn't want to hire him. He told me exactly what I needed to know, which was we're covered, we're good. And then I said, listen, let's stop this for trouble. How much would you give us so that we end this here? And they were the ones trying to sue us. But I said, you are clearly a breach of contract. So for trouble, you know what? I'm not going to go after the full amount right now. We do have an attorney ready to go, and we will win this case, but we just want to end it. There's a lot of chaos in the world right now. And it was a moment that we just wanted it over with. I mean, we could have probably not, taken nothing and just move on. Actually, no, we never just take nothing. I take that back. We would have gone for something. I was going to go for all. And, Floyd is just a very friendly firm. We just want to keep friends around. And they still like us. They actually want to keep working with us. Incredibly enough, we don't want to work with them. So, but they did pay us back. And they got a bargain, because if we were to go to court, keep in mind that court closed and shut down. And you know what that means? The lawyers just don't stop working because courts are closed. They keep trying to figure out how to milk the project by the minute, by the hour. I mean, they will call you to say how you're doing today, just to charge you. So, they will make up all kinds of things so that they can charge. And, it is the way they are. I mean, I'm sorry. I'm not trying to put anybody down. I experienced that situation. That's just from my opinion, my experience. They will milk it down. So they got a bargain because they didn't have to pay for the attorney fees. And neither did I want them to. To then give me the same amount of money that I was going to get anyway. So any of that, they didn't terminate the project on time. In fact, we were going back and forth on it for a while, about the project and doing the project. The other thing that they did, guys, and I want you to read this article on your own, but the other thing that they did was that they never provided payment for all of the sub-consultants that were required for the project, meaning surveying services, fire protection services that were required. I said, we need that. They never provided them. So the set of drawings that we provided was only architectural. And he said, this is only architectural drawings because you never paid, or you never pay the sprinkler engineers, you never pay the surveyors, you never pay the civil engineer. So they were in breach of contracts right from the very beginning because they never paid the consultants that were supposed to give us the initial information. Remember the initial information all the way back at the beginning? Hello? Nobody?
Yeah.
Yeah,
Yep.
the site related stuff.
Yeah, they didn't give me any of that stuff. So they were already in breach of contract. And one thing that they said, guys, and I'm very strong about it, they said, oh, wow, for the months For the months that passed, you never sent us an invoice for those services. I sent the initial proposals, I sent the initial contracts, I emailed them twice about it, and then I let it go. I'm not gonna be bothering you every week and every month about this. You've already been told like 3 times in person that we need this, that we gotta pay this. So, and the last thing I wanted to think about in March of 2020 was like, oh, these guys haven't paid the surveyors. Like, no, I wanted to make sure my kids were okay and everybody was okay. So, um, they were using the fact that I didn't invoice them as a sort of like protection. It's like, well, the fact that you don't get, I actually said this, the fact that you didn't get the bill from National Grid or T-Mobile doesn't mean that you don't own this, you don't owe for the services of using T-Mobile or Sprint or water bill. The mail just goes on and off, like it disappears sometimes I never get the mail. That's why they send you multiple ones sometimes. So that doesn't mean you don't owe them, right? Does it make sense? And that's when we got to check. They're like, okay, I'm not fighting anymore.
Dargan.
Yeah.
Just a little bit back on the example you mentioned about the client hand on giving the project to their relative, something. Doesn't it go related to the fact that the owner, I mean the client, never owns the project?
No, the client owns the project. He just does not own the instruments of service. It's his
Oh,
project.
okay.
He
Oh,
just
okay.
does not own the drawings.
Oh, I might have confused that in somewhere.
No, he does not own those drawings. He has a limited license for that particular project. If he was to actually take those drawings and go ahead and do another house like that, I would immediately sue him right away because he will
Okay.
have to pay me for that.
So in this case, you were talking about it was the same project, same location, and same everything.
He
Okay.
just got this other person to tweak the design a little bit, and
Okay.
he's never given us credit for anything whatsoever on the project.
Gotcha.
So the breach of contract is the fact that he altered my instruments of service.
Uh-huh.
It's kind of like falsifying the Jordans 1, and that's illegal. Like plagiarism. It's the equivalent of plagiarism when somebody uses somebody else's words and does not give them the the merit to it. That's it. They were sort of, because architecture is like a brand, right? Every project has its own branding. So they were taking my intellectual property and messing with it. Now they could be just going back to this project all the way in Las Vegas. I don't know if any of you has been to Las Vegas, but there is the Wynn Hotel, and then there is the Encore Hotel. Both of them are basically next to each other, and they look exactly the same because they are by the same people. They are the same owners. Across the street from the Encore and Wynn Hotel came about this other one. I think it's called like Happy something. I'm not sure the name. Well, turns out that they used, and I'm gonna go there. Las Vegas lawsuit. So there was a lawsuit going on. You see that design, that look? Guess what? That's actually proprietary to the Encore and Wynn group. Okay, and somebody else took that same design. Well, the story goes as follows, and I don't know much about whether it's true or not. The same contractor got hired to do the other hotel right next door. They happened to have purchased a lot of that glass and a lot of that stripe, that spandrel panel that you see there, and they over purchased it. They had a lot. The hotel right next door got the same contractor, and they said, well, we use the same thing. We use the same materials. We use the same thing. The design is different. The building is different, but they use the same materials. And because of that, they got sued very badly, like very, very badly. This is right here. Yeah, Resorts World is the name. Yep. They got sued. I mean, you can see that the project looks exactly like their project. You see it? So, Wynn Resorts has filed a lawsuit in federal court accusing Resorts World Las Vegas design of being too similar to its own. Guess what? Wynn alleges that Resorts World is using its registered and world famous architectural building design, according to filings in the U.S. District Court of Nevada. The company specifically cites its three-dimensional building with concave facade and curved bronze glass, coupled with horizontal banding above and between the lines of glass panes, also referred to in the suit as the trade dress. You see, these are the encore. You see in the Wynn right there next to each other? This is this one right here. Looks just like it. Now, let's see about how much money we're talking about here. All right. So that you see, they need to say it. Come on. They need to say it. Let's see how much. Because the amount of money, it's absurd, guys. Just because they use their design. I need to see the money. How much did it cost to build it? No, I don't know. It should say it somewhere. 17-page lawsuit, copyright. Yeah, well, you get it. They can't just use it. I'm sorry. It's just because in architecture, you know how like in when you're writing an essay or whatever, like sentences are your tools, your repertoire. You know, the words and how you put the sentences together is really an art form, and it can be copyrighted. It's owned, right? That's why we are taught the Chicago style citation methods or whatever. So in architecture or languages, you know, glass, spandrel, blue, green, and we do something that nobody has ever done. That's our language. That's our design. That's our thing. That becomes a brand. That becomes a logo. And the moment the World Las Vegas Resort World Las Vegas started using the same language, that was it. And you know what happens, right? People who come to Las Vegas and want to go to the Encore Hotel because they have a famous buffet, or the Wynn Hotel because blah blah blah, might just drive all the way into these Las Vegas World Las Vegas resorts by mistake. And we're talking about millions of dollars being invested on the wrong property because they associate that with the Encore and the Wynn. And the Wynn and the Encore could have already been, twice as expensive. Actually, thank you so much, Abelis. $4.2 billion on lawsuits. That's amazing just because they use that stuff. And they never thought that could happen. I mean, I'm not the smartest guy in the world, but I can see that happening. It's really easy. They were using somebody else's, even probably the detailing and the drawings. They probably got their hands on those drawings when they were doing it. So yeah, just do not use somebody else's instruments of service. That's really it right there. Now I don't I'm actually glad that these guys are not even citing me on their work, because quite frankly, it came out horribly. Um, and, uh, and this is actually being recorded. Sorry, I might be hurting myself a little, but the execution of the project came out horribly. Like the design was great, but the execution of the project was not so great. So this was a ranch house before, and we turned it into a two-story house. Um, and these three volumes at the top is ours. The idea of this garage is ours. This entry thing is not ours. That's not how it was supposed to be. The kitchen was basically existing. That they just renovated it a little bit on the first floor. But that wall is a signature element that we do, is a walk around sort of wrap around closet, and that's not how it's done. That's not how we do it. That's just not how we do it. That's just really a cheap version of our design. Um, some of these things are ours, some of these things are ours. But what can I say? It is what it is. I hope they sell and I hope they make good money. Um, so So what can I do in this case? Well, the first thing is I'm not liable for anything that comes after it. That's the pain. And if we are actually sued for any claims, we're protected. We won't lose. So, and we will get compensated, indemnify for trouble. So 7.5, let's read 7.4 real quick. And I think we're gonna end it here so that we can then finalize with 8 and 9, I think are the last two, I think, or so. So except for the licenses granted in this Article 7, no other license or rights shall be deemed granted or implied under this agreement. The owner shall not assign, delegate, sublicense, pledge, or otherwise transfer any license granted herein to any other party without the prior written agreement of the architect. Any authorized use of the instruments of service shall be at the owner's sole risk and without liability to the architect and the architect's consultant. Except as otherwise stated in section 7.3, the provisions of this Article 7 shall survive the termination of this agreement. Meaning, even after we've already been terminated, all of these licenses things are still binding. And with that, I'm gonna wrap it in there and we can talk about any questions you guys may have. And I'm going to upload these in our YouTube channel for a limited time. So enjoy it while it lasts. And you can call me if you need it for more time and we'll see what we can do. Thank you so much.